Probably the most important right in the eyes of the founders of this country was the right to possess property. And in fact, property rights in general have been so important that the founders included them in the Constitution more often than any other rights. Property rights are mentioned in Article 1, Section 9, Article 1, Section 10. Property rights are mentioned in the Fifth Amendment. Property rights are mentioned in the 14th Amendment. The founders' conception of property was very broad. For example, James Madison said that you have a right in your opinions. You have a right in your arm, in your leg. You have property in your arm, in your leg. You have property in the things that you own. You can have also property in your business. And of course, you could invest things. You can have property in your investments. So the concept of property can really be very, very expansive concept. Anything that's proper to you could be considered your property. There have been a series of Supreme Court cases that demonstrated the evolution of property throughout America's constitutional history, from being very important to being the most important right, to being gradually less and less important, to the point where by the time we reached the 21st century, property rights are no longer fundamental, but just are ordinary rights. So let's look at a series of cases very quickly and see what they tell us about property. The first one is Calder versus Bull, decided in 1798. In this particular case, Mr. and Mrs. Calder were beneficiaries of the will of Norman Morrison. Morrison died. He left everything to Mr. and Mrs. Bull, and they failed to claim, for some technical reason, the inheritance within 18 months. So because they did so, the probate court awarded the inheritance to Calder, and the Bulls were out of luck. So by the time they tried to claim their inheritance, the 18 months had run out. So they went to the Connecticut State Legislature, and they persuaded the legislature to change this restriction to, in fact, extend the inheritance claim period. And based on this new law, Mr. and Mrs. Bull sued, and they were able to win back what was explicitly theirs in the will of Norman Morrison. They won back their inheritance. And in this particular case, the Supreme Court said that no ex post facto law was passed in this particular instance. And the Supreme Court differentiated between ex post facto laws and simply laws that are retroactive. So you can retroactively do anything you want with the civil laws at the Supreme Court, but you cannot criminalize things after the fact. That's an ex post facto law. If you change things in a civil law after the fact, it's not considered an ex post facto law and therefore not prohibited by the Constitution. So the Supreme Court in this case for the first time considers in detail where property comes from, why human beings are entitled to possess it, and under what conditions the state might choose to regulate it. So John Marshall, writing for the court, said, "The general principle of law and reason forbid taking property from A and giving it to B." So he didn't say there's a specific provision XYZ of the Constitution that prohibits it, but he says general principle of law and reason. So the very nature of society is such that you cannot take what is properly A's, in this case, what is properly A's is, in his view, Mr. and Mrs. Bull's inheritance, because it was left to them in a will, and you cannot give it to someone else. And someone else, B, would be here, Calder. So you can't do it. So a very important case that signals just how significant property protection rights would be. But nothing reaches the kind of importance in terms of protection of property rights as Fletcher versus Peck. That's truly a high watermark of property protection in American constitutional history. This case was decided in 1810, and it was the first case in which the Supreme Court held a state law unconstitutional on the grounds that it impaired an otherwise valid contract. Peck was one of the original investors in a land deal called Yazoo land deal, in which four investors bought land from the state of Georgia. Today, this land roughly is the land that belongs to the states of Mississippi, the other states of Mississippi and Alabama. And all of those lands were sold by the state of Georgia at less than 2 cents per acre for investors, to investors, which even back then was an extremely low price. And the reason why the price was low was because the investors, and that's a charitable term for them, bribed the state legislature. Apparently, all but one member of the state legislature in Georgia took a bribe. So this deal was drawn up. The investors got land on the cheap, and then they sold it. And in most cases, people who bought land from the original four investors sold it to the next guy, and then the next guy sold it to the next guy, and so all the way down the road, seeing who will be the last person holding the bag. And what happened was somehow the initial fraudulent transaction was discovered. Everyone was voted out of the state legislature. The new legislature came in and invalidated the original sale based on the grounds that it was infected by fraud. And as the sale was invalidated, the people who were the last ones to have bought the land were left with nothing because they paid money for the land. But then the state of Georgia, by invalidating the original sale, effectively, legally took back the land. So Fletcher bought land from Peck, and Peck was one of the original purchasers from the state of Georgia. Fletcher sued Peck for his money back, saying that Peck has breached the contract because Peck sold him the land that really didn't belong to him, to Peck, because the original contract under which Peck acquired it was a fraudulent contract. So Fletcher says, I paid you money, and now the state of Georgia took my land from me, give me back my money. Sounds reasonable, but in actuality, Fletcher and his lawyer wanted to lose the case. What they wanted to happen was for the Supreme Court to say the original sale was valid, therefore Peck can keep his money, and Fletcher has to legally get his land back from the state of Georgia because the original sale was valid. Because if it doesn't go this way, if it goes a different way, if Fletcher wins the case and Peck owes him his money back, then everyone else who is the last person down the line is entitled to his money back, and you have a mess because you have all these multiple lawsuits now from down the chain, from the last person who bought the land upward to the people who sold it. So in some cases there were 5 or 6 sales transactions taking place. Too many lawsuits, too many things to fix. But if Fletcher loses the case, then what happens is whoever was the last person to have bought the land in all of these transactions keeps the land, and the sellers keep their money, and the state of Georgia keeps nothing. The state of Georgia is the loser. In this particular case, the Supreme Court decided that, in fact, it doesn't matter that the original sale was infected with fraud. What matters is that the purchasers who were buying things after the original sale, they were innocent. They had no reason to suspect the initial sale was fraudulent. They were operating in good faith. So the court, in order to help itself decide this case, uses the method of interpretation known as doctrinalism. It postulates or establishes a doctrine, in this case the doctrine of innocent purchaser, and it tries to determine whether the purchasers in this case were innocent, and the court determined that yes, they were innocent, they were acting in good faith. So Fletcher loses the case and keeps the land that he bought from Peck. Peck keeps the money. The state of Georgia is out of luck. All that land is gone. It's now in the hands of private investors. So what was the legal basis for the court's decision? Article 1, Section 10 of the Constitution that prohibits the states from impairing obligations of valid legal contracts. So this is an incredibly important case, and it's astounding in terms of the breadth in which property rights are protected. But the court's conclusion that the Constitution protects these innocent purchasers was not enough for one justice. Justice Johnson wrote that basically not even God can violate the right to property. That's a paraphrase, but it doesn't change his actual wording too much. His actual wording was, I would declare Georgia action unconstitutional, not necessarily because the Constitution says so, but because there's a general principle in the nature of things, a principle that would bind even the deity, meaning not even God can interfere with property rights. Very strange. Presumably, if God created everything, including property, God can take it back, but not according to Justice Johnson. According to Justice Johnson, property is greater than God himself. Next one is Trustees of Dartmouth College versus Woodward. In this case, the state of New Hampshire, where Dartmouth College is located, and more specifically, the legislature of the state of New Hampshire was upset that the trustees of Dartmouth College, which was a private college and still is a private college, fired the president of Dartmouth College for political reasons, because they belonged to different parties, the trustees and the college president. But the college president belonged to the same party as the majority of the New Hampshire state legislature. So the New Hampshire state legislature, when it saw that the trustees were not going to reinstate the president they had fired, decided to go around the trustees. But how? They said that Dartmouth College is no longer a private college. They said, we're taking it over. It's now a public college. They fired the old trustees. They put new trustees in, the politically pliable trustees. The new trustees reinstated the old president, and the state legislature of New Hampshire was happy. But the trustees who had been fired, now they were not happy. So they filed a lawsuit, and they claimed that the state of New Hampshire could not, in fact, make this Dartmouth College public. It simply couldn't take a private college and make it public. And the argument was pretty astounding. They said Dartmouth College was established as a result of the King of England granting land to Dartmouth College, and in exchange, Dartmouth College, or more specifically the trustees, all of that, of course, was happening in the 17th century. In exchange, the trustees, in exchange for that land that the King of England had granted them, the trustees agreed to establish a college. That was a binding contract between, get this, the English king acting as a private person and the trustees acting as an immortal abstract body. And the Supreme Court agreed with this argument. The Supreme Court has in fact agreed that when the King of England granted the trustees the land in the long bygone 17th century, that was a contract between the immortal trustees and the English king acting as a private person. And therefore, the state of New Hampshire could not, because of Article 1, Section 10, could not invalidate that contract, because that was a valid contract. And so the Supreme Court's decision made it so Dartmouth College had to go back to private hands, to the old trustees. They were restored, and the state of New Hampshire lost. Woodward lost this case. Next one is Charles River Bridge versus Warren Bridge. There had been a change of guard in the court in terms of its membership. Particularly Chief Justice John Marshall had resigned, and now there was a new Chief Justice, Roger Roger Taney. And the country itself has changed because what you had during the first 3 decades of the 19th century was very rapid industrialization. Industry was growing, the infrastructure was growing, the country was changing. In this particular case, you had another university involved. If you're wondering why universities are involved in so many old cases, it's because many East Coast universities are really old. I mean, some are older than the country itself. This particular case involved Harvard University, which is located in Cambridge, Massachusetts. And students, faculty, and staff, many of them who had to commute from Boston to Cambridge so they could get to Harvard University, commuted across Charles River. And Massachusetts contracted Charles River Bridge Company, a private company, to build a toll bridge so that people could commute back and forth between Harvard and Boston. And a bridge was built. According to the contract, it was supposed to be a toll bridge, and it was a toll bridge. That's how Charles River Bridge Company was making its money. But then, after a while, the state noticed that the bridge was too crowded because the state's population grew and there was a need for a second bridge. So the state chartered Warren Bridge Company and commissioned a bridge to be built by that company. The company was to build a bridge that would be only initially a toll bridge until the cost of construction is recouped, and after that it would be a toll-free bridge. Charles River Bridge Company was not too happy about that, and it filed a lawsuit against the Warren Bridge Company, trying to get the court to stop the Warren Bridge Company from opening a second bridge, because Charles River Bridge Company was saying Warren Bridge Company cannot do this. It cannot build a bridge because the initial contract that we have with the state is a contract for a toll bridge. And if Warren Bridge is allowed to operate a toll-free bridge, no one will want to use our toll bridge. So it is as if we cannot charge a toll. And it is as if the original terms of our contract are effectively meaningless. Well, in this particular case, the Supreme Court ruled not in favor of property owners, not in favor of Charles River Bridge Company. Justice Taney, writing for the court, said that private property is sacred, but we must also remember that community also has rights. And at least in this case, Taney and the majority on the court decided that the interests of the community were greater than those of the interests of the property owners of the Charles River Bridge Company. But I ask you, what was the state interest in Charles River Bridge? It was to build a second bridge so as to facilitate traffic flow between Cambridge and Boston. But what was the state interest in Fletcher versus Peck? It was to get back all those vast lands that the state had lost as a result of fraud. Where was state interest greater? In Fletcher versus Peck, getting back all those vast lands, or in Charles River Bridge versus Warren Bridge, facilitating traffic? I think that the interest in Fletcher versus Peck, the state interest, was greater. And yet, in Charles River Bridge versus Warren Bridge, where the state interest seems to be substantially less, the Supreme Court ruled in favor of the state interest and against the interest of property owners, against the interest of Charles River Bridge Company. So what has changed between the two cases? What has changed is clearly, as I said, the country has changed economically. You needed to build new infrastructure all the time, canals, bridges, dams, roads. Imagine if any time you try to build new infrastructure, some little business interest could sue claiming that its interests were somehow adversely affected as a result of this new infrastructure. You would be buried in lawsuits. So, and it's interesting that this is the argument that Tony actually made for the court. There was a dissenting opinion by Justice Joseph Story, who said, well, if this decision stands, then no one will want to pony up money for the development of anything. Because why would anyone pony up private money if they know that in the future the government can do something that undermines it significantly? So essentially, in this case, the two sides ended up arguing not so much over the technical details of constitutionality as over which economic theory is better. The theory that private interests should not be allowed to obstruct government development of the infrastructure, or the theory that government should not interfere with business interests, however small, because if it does, then private businesses will not want to invest. Anyway, the next case is Munn versus Illinois. It involved the interests of farmers who took over in a legal, normal manner the legislature of the state of Illinois. And the legislature of the state of Illinois passed a law that imposed maximum prices on grain storage. So owners of grain storage elevators could no longer charge whatever it is they wanted to charge farmers to store grain. And the reason why farmers wanted to store a lot of grain by the end of the 19th century was because productivity improved. And as a result of that improved productivity and the construction of railroads, farmers could produce enough to sell grain at distant markets. And so they now competed with each other, not just locally, but nationwide. And if you wanted to store your grain, you had to pay. And the Illinois state legislature said it's unfair that farmers should pay grain storage elevator owners whatever it is they request. So once the legislature established these maximum prices, the owners of the elevators sued. And this is where you have Munn versus Illinois. This case involved the 14th Amendment, and specifically the Due Process Clause of the 14th Amendment, which says, among other things, that the state cannot take property without due process of law. And in this particular case, Munn claimed that property was taken without due process of law. The legislature simply made a law. There was no judicial process to say that there's some kind of bad act was committed by owners and that they should pay a fine. The legislature simply passed a law that simply took property away from them. So the Supreme Court ruled in favor of the state of Illinois. Justice Morrison Waite, writing for the court, said that private property is no longer completely private if it is closed with some kind of public interest. Very interesting. This is actually an ancient doctrine, but when you resurrect it in a more modern context, you might be on a slippery slope toward severely limiting property rights. Because let me ask you this: when, if ever, is private property not closed with some kind of public interest? And if it is always closed with some kind of public interest, then when is private property truly private? Some people would say never. Do you really own your house? What happens if you, say, paint your house, I don't know, black and pink, because you say these are your favorite colors, and the city tells you you're crazy? They tell you you cannot change the color of your house without permission. And we would never approve black and pink houses because all houses here are sandy color. You're living in the desert here. When is your property truly private? So, or let's say you're driving your car at night and your headlights are broken And the cop stops you, says, well, you have to fix the headlights. And you say, well, that's my property, so I don't care. Who do you think will win this? The cop will win this. The state, right, will win this because they will say, well, there's a public interest involved here, and that's safety. You have to maintain your car in a certain condition. And what happens if you really truly can't pay to fix your car? It is almost as if you don't really own your car because you can't use it. So the immediate significance of Munn versus Illinois was that it gave the states a virtually unlimited right to conduct economic regulation. Notice that economic regulation is really at stake here, and the specific type of economic regulation is maximum prices. But the significance of the case extends far beyond maximum prices, because clearly the court's decision is quite sweeping. Once again, Morrison Wade, when private property is closed with some kind of public interest, it's no longer completely private. 1 year after this case was decided, the American Bar Association was formed. Now, today, the American Bar Association is the largest and probably the best-known association of lawyers in America. It was formed in 1878 with one purpose in mind: to build the intellectual and political muscle to eventually get the Supreme Court to overturn its own decision in Munn versus Illinois. And less than 3 decades later, the Bar Association in fact succeeded. In Lochner versus New York, the Supreme Court overturned New York state law, which imposed maximum working hours on bakers. So the facts of the case were simple. The state of New York said that bakers could only work no more than 60 hours a week. And they justified this law based on safety considerations. They said the bakeries are hot, it's a difficult physical labor, you're almost always on your feet. So if you own a bakery and you want to employ a baker, you can employ him, but for no more than 60 hours a week. And of course, if you're a baker, you could not work in that bakery for more than 60 hours a week. Now, Joseph Lochner, an owner of one of these bakeries, broke the law, and he was fined. But he said, this law is invalid. The state of New York cannot pass such a law. It's unconstitutional. Now, if Munn versus Illinois were to be your guide, then you would say it's an easy case. Because I just said that Munn versus Illinois gave the states a virtually unlimited right to regulate private property. And precisely because this was the easy case, the court went the other way. The court said that New York state law violated the due process clause of the 14th Amendment. And particularly the language that said that no state shall deprive any person of life, liberty, or property without due process of law. And the court said that, in fact, it is liberty that was denied here. You see, they couldn't quite say that property was denied here because of Munn versus Illinois. But they said that, in fact, it was liberty that was denied here. But what kind of liberty? They said, it's liberty of contract. If you and I want to make a contract that you employ me 65 hours a week and not 60 hours a week, who is the state to come in and say, no, you can't do that. You only have to work no more than 60 hours a week. The problem with this reasoning is the Constitution does not have any such language. It does not speak about liberty of contract. It mentions liberty, but not liberty of contract. What is this idea of liberty of contract? Where does it come from? The answer is that it comes from the judge's own ideological preference. It comes from a particular economic theory, the theory of laissez-faire, free hand, laissez-faire, or free market. Let the market decide. If adults want to agree to work on an X number of hours, it's their freedom to do so. And to stop it is to violate their liberty of contract. The problem is that the Constitution does not have in it any specific economic theory. It does not have in it the theory of free market or theory of not free market. It just doesn't have any economic theory. If it had, then the court would undoubtedly be right, but it doesn't. So the court substituted its own judgment in place of actual constitutional law by reading into the word liberty an entire economic ideology. So today it is widely believed that this is an infamous case. Infamous is opposite of famous. It means famous but bad. It's an infamous decision because in this case the justices substituted constitutional law with their own judgment, and no judge is ever allowed to do so. A judge is not allowed to engage in creative decision making. A judge is not an artist. A judge cannot say, yeah, I know what the law is, but who cares? Or a judge cannot say, I will pretend that the law says what it actually doesn't say. Therefore, Lochner versus New York is no longer just a name for a badly decided case. It became part of culture. And in fact, you can say that to accuse a judge of Lochnering or Lochnerizing is the worst insult that you can level at a judge. To say that a judge Lochners or Lochnerizing is to say that he or she is substituting his own values, his own ideology in place of the law. Judges are not allowed to do that. Anyway, in 1937, in West Coast Hotel versus Parrish, Lochner versus New York was overturned. In this particular case, Eliza Parrish was employed by the West Coast Hotel in Washington State, which is still around, and she was paid less than the minimum wage. She sued. The West Coast Hotel said, "What's the problem? We do not have to pay minimum wage." And the state of Washington said, "Are you crazy? Of course you have to pay minimum wage. We have in this state minimum wage law." And the West Coast Hotel said, but your minimum wage law is unconstitutional. Look at Lochner versus New York. There's liberty of contract. We can employ people here on any terms that we like because government cannot interfere with liberty of contract. She made a contract. If now she discovers that the terms of this contract are incompatible with the state law, and she wants to invoke state law to get paid at least the minimum wage, she can't do it because the state law is unconstitutional. You see? The state law that requires the minimum wage is unconstitutional. You can see how Lochner versus New York and West Coast Hotel versus Parrish are conceptually one case. The facts are different, but the questions are the same. And so in this particular case, the court in a 5-4 decision overturned Lochner versus New York, and the entire Lochner jurisprudence came to an end. From then on, the state could once again impose all kinds of economic regulations. The last case I'll mention is Kelo versus City of New London because it's so interesting, and it involved the taking clause of the Fifth Amendment that says that private property cannot be taken for public use without just compensation. Private property cannot be taken for public use without just compensation. This is quite interesting because what happens in virtually all of these cases when the government takes property and pays compensation to a person, the person really has no claim. The person will always lose because the courts will say, you got your compensation and the government needs this land in order to develop whatever. They want to build a gourmet cannoli stand. I don't know. They will sell low-calorie cannoli, if there is such a thing, in this place. and that's under the eminent domain. They're taking your property away. You got your $200,000 for your house. Go away. You lose. But this case was slightly different because in this case, the government, and particularly the city of New London, didn't directly take the house from Suzette Kelo. Rather, they took Suzette Kelo's house and gave it to another private party. They gave it to a developer after the developer had submitted plans to the city of New London for the development of a shopping mall and maybe some other stuff. I don't quite remember. But anyway, this did not faze the court. The court still said that the city of New London wins. The city of New London has a constitutional right to do what it did because in effect, in actuality, when it took Suzette Kelo's house, first, it gave her compensation. But second, it didn't really give it to a private developer. It only kind of gave it to a private developer because the private developer was acting totally on behalf of the city of New London because it was acting in accordance with the blueprints that it submitted to the city of New London, that the city of New London approved. So it was still development on behalf of the city of New London, even though it was not conducted by the city of New London, but by a private developer for private profit. So Suzette Kelo lost and the city of New London won. It's interesting, just as a footnote, that soon after this case, the developer actually went bankrupt and abandoned the plans to build what it was planning to build. And some activist group actually purchased Suzette Kelo's house, took it off of its foundations and brought it into some visible location. And they did so in order to demonstrate visually the government's incompetence. And they said, you see, the government took a house from a person who lived there for a very long time, and they did nothing with it. Just to demonstrate kind of government's inefficiency and incompetence. But what is important is that in the course of time, there's been a depreciation, a diminution in the importance of the right to property. If this right was the most important right for the founding generation, if Fletcher versus Peck protected it up to the heights that are hardly imaginable, and if it was a fundamental right, it certainly is a fundamental right no more. It is still protected, but the kind of protection that it enjoys today is very, very limited. It would be fair to say that the right to property is no longer a fundamental right, but rather an ordinary right on par with many other ordinary rights, which can be easily limited if only government uses reasonable purposes, any non-insane purposes, and any non-insane means to limit it.